Our next case is Janetsky versus Saginaw County. Good morning. This is a 15-minute mini oral argument on the application. We both have 2 minutes of a free fire zone, which you may waive. You have time for rebuttal, but we ask that you keep track of that time if we do not use it up, and you may begin when you're ready.
Good morning, Your Honors. Channing Robinson Holmes, appearing on behalf of the plaintiff appellant Jennifer Janetsky. I'm joined at counsel table by my co-counsel Carrie McGee. I'd like to reserve 2 minutes or whatever time I have remaining for rebuttal. May it please the court, there are several legal issues before this court today, but with the short time that I have, I'd like to begin with Janetsky's claim under Michigan's Whistleblower Protection Act. While we've identified several different bases for reversal in our briefing, this case presents an opportunity for this court to clarify the terms of the WPA, similar to this court's Miller v. Department of Corrections decision issued last year, which clarified the meaning of the language set forth in the Elliott-Larsen Civil Rights Act. Following the rules of statutory construction in that case, this court unanimously concluded that the ELCRA prohibited retaliation against a person and does not specify that the person need be the plaintiff. The same logic applies here as the WPA prohibits an employer from retaliating against an employee and does not specify that the employee need be the defendant employers. Hearkening again to Miller, this court noted, quote, intuitively, the notion of retaliation suggests that a plaintiff must allege retaliation by a defendant against themselves, end quote. So too does it seem intuitive that an employer must retaliate against its own employees, yet like this court held in Miller, that is simply not how the statutes read. All that is required to state a claim of retaliation under the WPA are an employer, an employee, a protected activity, an adverse action, and a causal connection between that adverse action and the protected act. It is our contention that the WPA prohibits an employer from retaliating against any employee, not its own employees. And therefore, whether Saginaw County was or was not Janetsky's an employer is an unnecessary inquiry under the statute and an avoidable obstacle to Janetsky's access to justice under a remedial statute. Turning next to Janetsky's public policy claim, the Sukadolski court held...
I'm sorry, Counselor, on the employment question, would you have us just look at the language of the statute or things like the collective bargaining agreement, or do we want to look to those external factors under your reading here?
Under my reading of the statute, I don't think it's necessary to go into a fact inquiry as to whether there's an employer-employee relationship between the parties. I think the statute, similar to the ELCRA and this court's Miller opinion and analysis of the ELCRA, demonstrates that, that there's no limiting language to what an employee is or the relationship between the parties. It simply states an employer and an employee. So analysis beyond that is really irrelevant and superfluous.
So the relationship questions go to your requirement to prove causation. Is that where those are going to come into play?
They may come into play, yes, because of course you do have to prove causation, and whether the employer in question was able to take adverse action against that employee would speak to causation.
So I think reading between the lines, I think the Court of Appeals was struggling. They sort of got to this end result that the county couldn't have done anything. They really weren't a decision maker. They had no power in this relationship, and they used that analysis, I realized, to get to that result. Does it matter that if you have this joint employment situation that one of the employers really is not a decision maker?
I think, well, first I think that opinion kind of presupposes that is a valid conclusion. That
fair enough. Understood. There could be fact issues on that. Understood.
When we turn to the factual questions, as Justice Thomas pointed out, there's definite evidence that the county had a say in the terms and conditions of Janetsky's employment. We can turn to the collective bargaining agreement for that, the letter in which they identify themselves as co-employers, and and dictate her reporting structure. And so it does become a fact question, but again, that shifts to a causation analysis.
Thank you.
The Sukadolski court held that that courts have occasionally found sufficient legislative expression of policy to imply a cause of action for wrongful termination. And here, under MCL 771.1, we have a sufficient legislative expression of policy. And actually, Chief Justice Clement took the opportunity to opine on this issue in her separate opinion the last time this case was before this court. And we point to that separate opinion as really thorough in explaining why MCL 77.1 is a formal legislative expression of the state's public policy. And this state and this legislature presumably prefers to see that policy and act obeyed. And when Janetsky made an effort to remedy the plea agreement underlying the criminal case in this suit, to bring that plea into compliance with MCL 77.1.
So counsel, I wasn't on that part of the opinion before, but let's just assume that ship has sailed with where I was before, and we jump forward to where Justice Clement is. I agree, she makes some great points in her prior opinion. The one thing I'm struggling with, what do we do when it's someone's job, as an attorney in offices all the time, we disagree about the law, we disagree how the law gets applied. I mean, I've worked in a law firm, you might spar with your co-associates or the partner on the case and disagree. What do we do where it's literally our job as lawyers to interpret the law and advocate for a position, and we sometimes might internally disagree about that? Is there a point where, is there like a line on this where one is, yeah, that's okay, that's not actionable, but now it's a public policy claim because some threshold is crossed?
Well, I think, again, we can turn to Chief Justice Clement's opinion, and she articulated that there would have to actually be a violation of law for this to have that claim. So it would not be, there are of course disagreements all the time, but this is an actual violation of law. The plea was determined to be outside of what was allowed under MCL 77.1. The chief prosecutor agreed with that. Defendant Boyd agreed with that. That's why they entered the motion to withdraw the plea. So there really wasn't a dispute about whether it was a lawful plea. There was just simply, oh, we made an error and now let's correct it. So
anytime there's a disagreement in the office and maybe an error, understanding this case has more facts, and I understand that, is that employee now has public policy protection for raising the error?
So taking your hypothetical, if there had been a dispute, and in fact the plea, as here, was determined to be an unlawful plea, and Janetsky, as here, took steps to remedy that unlawful plea, and she was subsequently retaliated against, that would give rise to a public policy.
Because I can just think of lots of examples in the criminal context. My goodness, scoring and recommendations on sentencing and the guidelines, and where mistakes happen all the time. We see them all the time on the back end. A lot of times they're really just a mistake. So I guess if someone's internally trying to correct that then, under your view, there's public policy protections at that point.
Yes, and I think it's important
The retaliation has to take place, though.
Exactly.
Okay.
Exactly. So it wouldn't just be, oh, we disagree and I'm gonna, correct this, and now there's a public policy claim. There's retaliation, there's an adverse action that takes place, and presumably that is not happening all the time in the workplace when we have disagreements about our interpretations of the law.
Thank you.
So, as Chief Justice Clement, previously pointed out, achieving compliance with the law, in my view, is the functional equivalent to refusing to violate the law. And I don't think that this court should find any differently. It certainly wouldn't be in the state's interest under public policy to find that there is a difference between those two actions. And the Michigan Association for Justice, their amicus brief, pointed to several cases in other jurisdictions which found that there were public policy claims in similar settings. And I think those are really important to look to in this case. Moving quickly through the legal issues, as there are several, turning next to Janetsky's false imprisonment claim. Here today we're asking the court in part to hold that there is no requisite time period attached to a prima facie claim for false imprisonment.
So counsel, I guess the question I have on that is, and I think you're getting to it, so, but I figure I'll just jump in. Is the question when you're dealing with false imprisonment that it goes to the intent, not the time?
Right, so the Court of Appeals held that the brevity of the false imprisonment speaks to speaks to her consciousness of confinement, which we don't believe is applicable. We believe that any sort of brevity speaks to damages of that confinement. And just like a battery can be very brief in nature, that doesn't mean there's no damages flowing from that. So false imprisonment, it could be very brief, but it does not mean that
So
there's
is
no
it the
damages.
closing of the door? Is it the holding of the handle? What is it that actually constitutes that?
The false imprisonment piece?
Yes.
So that would be when Janetsky's hand was on the door and Defendant Boyd slammed the door above her head, and she was confined in that space. I believe the testimony is pretty clear that it is a brief time period. I think it's only about 30 seconds that she believes and felt consciousness of that confinement, but that doesn't mean that there was no harm flowing from
Right,
that.
I see, okay.
One of the main reasons we believe that this brevity argument should be overturned is it comes from obiter dictum in Moore v. City of Detroit. And it really was not a critical component to that Moore decision. The Moore court really just threw it in there after making the decision that there was no false imprisonment. And they rely on the Willoughby v. Lairbass case, which did not speak to brief confinements. Rather, the Court of Appeals in that case was examining who, if anyone, had detained the plaintiff, and Defendant Lairbass did not take, quote, any act which resulted in the detention of the plaintiff. So it really did not speak to the brevity and spoke to who had control and the intent to detain the plaintiff in that matter. And in fact, when you look at the Willoughby case, there's no other opinion that cites to Willoughby for that contention that brevity can preclude a false imprisonment claim. Quickly, we also are in part asking this court to opine on the Court of Appeals decision that the Court of Appeals held that Boyd, as Janetsky's supervisor, is entitled to, in some fashion, falsely imprison her as her supervisor. And we're asking that this court overturn that portion of the opinion. There's certainly no support for the Court of Appeals to have make that holding. And Chief Justice Clement, again, in your separate opinion the last time we were here, briefly opined on this in terms of governmental immunity, but I think that analysis is still applicable here. A supervisor is not the equivalent of a police officer, should not be given any sort of privilege when it comes to an intentional tort. And with that, I will reserve my remaining time for rebuttal. Thank you.
Good morning to the court. Douglas Curlow on behalf of the defendants appellees. I will be concise. I am still in chemotherapy, and the loss of hair, the cosmetic effect, is just the tip of the iceberg for the effects one experiences. I do not have the stamina that I would normally have. Just very briefly to hit the main points. As far as the Whistleblower Protection Act claim, it is our position, as stated in the brief, that the point of the legislative intent behind the Whistleblower Act is clearly to impose liability on a party that can do something about the discharge or the conditions of employment. And in this case, Saginaw County did not have control over the right to hire and fire and the conditions of employment. Statutorily, that is in the hands of the prosecutor as an independent constitutional officer, as long as they don't yield it to the county. And in this case, as in the case of other prosecutors I've represented, they don't yield that. They maintain control over their office and the conditions of employment. The county couldn't have stepped in. And so it serves no purpose for the county, albeit a co-employer that's paying the salary, to be held liable under the Whistleblower Act because they had no ability to control the conditions of employment. With regard to the public policy claim, which this court in its previous order defined very carefully to avoid preemption by the Whistleblower Protection Act, said the public policy claim is based specifically on the allegation that there has been a refusal, that she was retaliated against for refusal to violate the law. Janetsky was never put in the position of having to refuse to violate the law. By her own testimony, she went to McColgan with her report, her whistleblower report, that Boyd had screwed up on his plea, and McColgan empowered her with full authority to correct it in accordance with what she felt ought to be the solution. And that was communicated to Boyd, who admitted that McColgan told me that he'd authorized her to correct it, and although he disagreed with the legal interpretation, he signed off on the motion that Janetsky had drafted to withdraw the plea. So where was the
I'd love to jump in on the independent contractor analysis. I have to admit, I understand what the Court of Appeals was trying to get to as far as sort of control and ability to maybe remedy the situation, but I am troubled. That test is used in employment law world to determine who gets unemployment and workers' comp. And so, certainly you're not suggesting that all of the assistant prosecutors no longer are eligible for those benefits through the county, are you?
No, what I'm saying is that for purposes of a Whistleblower Protection Act liability.
Right, but it's a test that is
act,
kind of like you either are an employee or you aren't. It's not usually used to say just for this one time.
Right, well, we never denied that she is, in fact, a co-employee. I think the law is very clear that she is with the county as a co-employee. The question is, can you be liable under a Whistleblower Protection Act claim as an employer when you're the party that has absolutely no control? That's not being an employer, that's being an insurer.
But we've had this for a long time, right? Since the Whistleblower Protection Act has been in place. There are lots, and particularly the public sector, there are so many examples of, I can think within our court system, you've got your courthouses, and maybe the paycheck comes through, the local municipality or whatever. You technically work for the city, but the court's pretty independent, the judges and all. So this is a pretty common problem. So that would be a pretty giant detour in the world of joint employment.
Well, it's why the economic reality test is applied. You look at who has control over it. Somebody's going to have control over the employment. There's no employees, I wouldn't hope, running around in the public sector who have no one they report to and no one they're accountable to. Somebody has the control over their employment, and somebody has the ability to hire and fire. And whoever that is.
Why isn't that an issue to be addressed through causation?
Pardon me?
Why isn't that an issue to be addressed through causation? When the statute defines employer and employee, and in fact, I think in other contexts, we don't supplant a statutory definition with the economic reality test. But why all these points of how could they have affected it, what relief could they have given, all of those things, why is that not an issue of causation as your opposing counsel suggests it is?
Well, as this court pointed out in the Clark versus United Technologies case, now it was a workers' compensation case, but they applied the economic reality test because they said you have to look and interpret the statute in accordance with the overall statutory scheme. You look at their word was the employment situation in light of the statutory scheme. In this case, what is the statutory scheme? The statutory scheme is to prevent discrimination in hiring and conditions of employment and termination. And in light of that purpose, that legislative purpose of the statutory scheme, it does no good to impose liability on Saginaw County that can't do anything about it. Where the liability needs to go is on the prosecutors, as the prosecutor as an official capacity, as the employer who has the control over the conditions of the employment in his office. That's what the purpose of the statute is. So if you're looking at the legislative intent and interpreting the statute and applying it to the employment situation in accordance with the statutory scheme, you can't just say any employer. I think in my brief I gave some examples of how attenuated that could be, where you have one employer, where you have a person working for the law firm, and yet they can sue their law firm because they were discriminated against by a completely different entity that employed
Counsel,
somebody.
I have a question. First off, I'm sorry for what you're having to go through, so I'll keep my question brief, but just trying to use the example that you're giving to how things work here at the courthouse. Each one of us justices has a team of 5 people that work with us. So if something were to happen in one of our offices, is not the court responsible, or are we indirectly responsible as judges for what happens within our own chambers?
Well, I don't know exactly how the arrangement is in the employment situation of your staff within the court, whether you have any right to hire or fire.
We hire and fire, just like in this case. Okay.
I would say in that circumstance, if you're controlling the conditions of employment in your office, if whether you, the hours or what demands you put onto your staff, or whether you can hire or fire them, I would say that in fact for Whistleblower Protection Act, you would in fact then be the party who should be held liable, because you've got the control. Within the statutory scheme, you can address the point of what that statute is trying to control. Whereas the court more broadly, if you can override what anybody else around here wants to say, and you can control it, then I would say that you would be the one that would be responsible under the Whistleblower Protection Act.
Got it. Thank you.
Again, as far as the having to refuse, again, our position is that she never had to refuse. She was authorized to do it her way, and not just, I think one of the court opinions used the phrase that she attempted to rectify the situation. No, she did rectify the situation with the plea exactly as she wanted it done.
But she had to make that choice, right?
Pardon me?
She had to make that choice to let it stand or to go.
Sure, but the ultimate decision was hers. McColgan put it entirely in her hands and said, it's up to you to fix it the way you want. And Boyd said, yep, I was
Right,
told.
that's when she brought it up, but could the fact that she would, if she did nothing, this would have gone in
Right, but that goes into the whistleblower claim. Remember, this was the court here that bifurcated those two claims.
Mm-hmm.
The whistleblower report part of the aspect is what supports the whistleblower claim, and this court avoided preemption by saying, but the public policy claim is predicated on the entirely different act that she supposedly had to refuse to violate the law. Well, she never had to refuse to violate the law. She shows up, she gets back, find out what Boyd's done. Let's assume arguendo that he screwed up. She goes to McColgan and says, Boyd screwed up. He offered a plea that he can't offer. It's illegal. It's unlawful. McColgan, what's his response? Well, you go and fix it as you think it needs to be fixed. And then he tells Boyd, she can fix it the way she thinks it needs to be fixed. She fixes it the way she thought it needed to be fixed. I don't see how that's having to refuse to violate the law when you're given the authority to make the decision to fix the problem, the supposed violation, exactly how you think you want it done. I turn to the false imprisonment, which was the other point brought up in counsel's presentation. It was suggested that we not look entirely at the time. Well, I think the Moore versus Detroit case does look at the time. I think it's more than dictum. But I think more importantly, what that case looks at is the context within which the person is detained. And in that situation, it was a context of an employer trying to investigate a problem in the workplace. And it's a question of context matters. Just like...
But didn't he slam the door as she was attempting to leave?
Oh, he didn't slam the door, as you can go through our brief with a very extensive citation to exactly how she described it. The door was closed at the outset of the meeting, as soon as the intern had been ordered out of the room. Right. And then what he did was he put his hand on the door. She announced that I'm going to go now, was her words as she testified. He put his hand on the door to stop her from opening it, held it for less than 30 seconds before he opened it, and at that point, she voluntarily stayed. He called for Nate Collison, the union representative, came in, she stayed, she chose not to leave.
Well, maybe, I mean, isn't that an issue of whether or not she actually has damages from that, not whether or not, in fact, was a false imprisonment?
Well,
The length of time, the fact that, you know, all of those things, wouldn't that be something that a jury would consider as far as calculating damages?
well, except what I emphasize in the brief is the point of the context in which he's being detained. And I think the Court of Appeals correctly held that an employer has to have some ability to control employees in the sense that they can't just run off and run away from a confrontation with a supervisory employee to address a workplace issue.
But you can't
Why
put a
not?
physical
Why
barrier.
can't they?
Yeah, I'm sorry.
No, I was just saying, I mean, why not? They may jeopardize their job
Right,
if
well-
they run away, but
It-
are you
it
suggesting
certainly-
that there is some modicum of physical restraint that somebody can?
Well, again, well, one, he held the door, it was only, again, it goes down to the temporary time, but what they have is a situation where, as I point out in the brief, I think I described the alternative, is if you say, okay, then he should have just said, okay, you want to talk to me, you're fired, which certainly he could have done, then that just creates a public policy dismissal claim. Oh, you dismissed me for not listening to you, and so I think that's what conditions of my employment. So you're damned if you do,
No, I mean,
you're
there's,
damned if you
there,
don't.
there's a spot in between that, where,
What?
there's a place in between that, where, you know, she leaves, he does not close, keep the door closed and prevent her from leaving, and then sets a meeting with her and someone else in the room, right? I mean, there's other things before it's just immediately you're terminated.
Well, just because there's alternatives doesn't mean the one he chose was wrong. What he said was, I want to confront this now. We're talking about the issue now. We're going to
Which
confront
again
the
is
issue.
fine. The question is whether or not he has the right to put his hand on the door and prevent her from leaving.
Well, it's his door, and they're having their meeting of a workplace issue, and I think that as a matter of policy, he has the ability to insist, I need my employee to listen, I need my...
So here's, okay, let's say that you're right about this, and we're in a remote work world where it's all by Zoom, and I'm Zooming with someone that works for me. I have the ability to do what in that situation? How do I, if I say I want to address this right now, what am I able to do?
Well-
They hang up the Zoom, they get off the Zoom, can I
Well,
just,
Again, context matters. In that situation, you can't stop him. In his situation, she's in his office, he's got a door, it's already closed, he just prevents her from opening it for 30 seconds.
Can he put his hands on her and force her to sit down?
No, and he didn't. He held the door.
Well, obviously he didn't, but, I mean, why? What's the line? Why is it okay to close a door that she is attempting to leave and some other mechanism to physically keep her in the room?
Like I say, it comes down to a question of policy and what an employer has to do. Remember, the situation here is, if you do not put it into a situation where an employee has to listen to a supervisor, then in the case like here, we have a public employee whose actions are detrimental to the public, could be detrimental to the public. In a private employer, you've got an employee whose actions can be detrimental to the consumer base for that company. Employees need to be supervised.
okay, so you're saying he can hold her there for 30 seconds, keep his hand on the door for 30 seconds. Can he do it for 3 minutes?
Well, it's a question of the
that's
context,
my
a question
question.
of what does he do in those 30 seconds.
He's talking to her,
I would say, yeah.
30 minutes.
Well,
Sit down, we're gonna talk about this until I'm satisfied as your supervisor that this is resolved. How
Well-
long can he keep her there?
Well, eventually you're beating a dead horse as far as his concerned. But, I mean, it's obviously, I don't think you can tie her up overnight. But you can certainly keep her there long enough to finish the discussion.
I
And I
just
think he has a
can't
right to finish
imagine-
that discussion to the point where he's made his point and satisfied himself.
But
more
counsel,
importantly,
I just can't imagine doing that to one of my employees. I just can't imagine holding the door and telling my employee they can't leave until our conversation is. It just seems really out of bounds, does it not? It just feels I just think that this is something that's quite out of bounds, out of the normal workplace activity.
I guess we just disagree on a matter of policy, because I don't think it's out of bounds at all. I don't find it odd or out of bounds at all. But more importantly, to get back to my original point that I was going to, in the Clark versus Kmart case, the point is, if you decide to stay, then there is no false imprisonment.
But it's a different circumstance when someone else is brought into the room, someone representing an employer, or an employee, excuse me.
Which Boyd agreed to do, just as she asked. I want my union rep.
Right.
Oh, okay, we'll bring him in.
Well, let's assume that your situation of holding someone against their will for 30 seconds or, any amount of time. But once someone else is invited in, that changes the dynamic, where maybe someone is no longer concerned about their safety or feels threatened or feels like they can't leave the room. So bringing a third party in changes that dynamic.
Maybe it does, maybe, I don't know that I'd say it was necessarily changing the dynamic. She's still, at that point, she could have left. After the 30 seconds, she could have left. Collison didn't even have to get into the room. She could have left. He opened the door.
Right.
But she chose to stay at that point, and she was going to hash it out with him. And apparently, according to Collison's description and her own, they had quite a discussion, which obviously is what Boyd wanted, and the discussion did end.
Okay. I don't see any other questions. Okay. Thank you. Thank you very much.
Thank you.
Appreciate it. You have a little over 2 minutes.
Thank you. Just very briefly would like to return to counsel's argument that the economic realities test should apply under the WPA. First, I think the application of the economic realities test would, of course, lead to inconsistent results. Here we have that the Court of Appeals weighed that 2 factors favored Janetsky, 2 did not, yet Janetsky still was not deemed an employee of the county under the WPA.
Is there anything in the WPA that requires control when looking at the employer-employee relationship?
No. Okay. There's nothing read into the statute that requires control. And as I was saying, another court could easily find that 2 factors favoring Janetsky would then create a question of fact that led to her being an employee under the Act. So it really would lead to inconsistent results for a whole variety of employees across the state who otherwise would have access to this remedial statute.
Can you address opposing counsel's position on the second issue of the public policy claim that plaintiff didn't refuse to violate the law because she was granted permission to do anything that she needed to do or wanted to do to remedy the violation or suspected violation?
So I think that it's a functional equivalency to me, whether you refuse to violate the law up front or whether you discover a violation of law and you take action to remedy that violation, and then subsequently you're retaliated against.
What about his argument that latter, where you see no distinction, that we've made the distinction between that being a WPA claim and a public policy claim is the refusal to violate the law?
So, but not under...
Reporting a violation of law or suspected violation of law falls under WPA.
But there's still a factual distinction between a report, especially given the last 2 years of jurisprudence from this court on what it means to make a report under the WPA versus a more passive action of correcting a violation of law. So a report has to be, more explicit. There has to be, intent there behind that to make that report a violation of law. So for example, Janetsky did that when she reported the violation to McColgan, but the separate distinct activity that this court has already ruled on is her efforts to bring the plea into compliance. That's a whole separate activity.
So correcting the violation of law, even if it was with the blessing of the prosecutor, correcting the violation is the equivalent of refusing to violate it.
Yes, I would say so, but I also would say that there's not necessarily a blessing that occurred given the facts in the case and the retaliation that takes place.
Right, okay.
And counsel, I have a last question. Assuming I agree with all the facts as alleged by your client, we've got false imprisonment, assault, and battery. Can you outline the elements for battery that in your view are satisfied here?
Yes, so, if I may just.
Yeah, no problem.
So battery is the intentional, unconsented, or offensive touching of something closely connected with a person. In this case, Janetsky's hand, she testified, was on the door when Boyd came behind her and slammed that same door to keep her from opening it.
Okay, so you're not alleging that her body itself was touched, but the extension with the door?
Exactly, her hand being on the door, to the extent that she could, she testified, quote, "All I could feel was the slam, the bang of the door." We believe that that is sufficient to create a battery, and of course then, because there's a completed battery, there's an assault.
Okay, thank you.
Any more questions from the court?
I don't see any. Thank you
Thank you.
both. The case will be submitted.
Thank you.